October 28th. Good evening and welcome to the August 17th meeting of the Zoning Board. Let's see, we have to have 5 members. Can I do that first? In appointing voting members tonight. So we have 3 in Councillor Hoffman, myself, and Mrs. Cheney. So I need to appoint technically Tim Whitney and Nicole Arsenault as voting members tonight so that we have a full board.
Perfect.
Okay, so can we have roll call, please?
Tim?
Tim Whitney?
Oh, yep, sorry. Councilor Hoffman?
Here.
Marcia?
Marcia Hayward is here.
Marcia Hayward, sorry. And Deb Cheney?
I'm here.
And Nicole Arsenault.
Here.
And I'm Robert Mora. I will be taking the minutes this evening, and I'm also staff in attendance, so I'm also the planning director.
You are it.
I am it tonight.
You are it tonight. We have to have a motion to accept the minutes of the July 20th zoning board. Do I have a motion, please? Councillor Hoffman, second. Nicole, thank you. All in favor of the minutes? There we go. So with that out of the way, we can approach our first application, which is 86 Chapin Terrace. Again. And for members of the audience, please be aware that although this was denied by this zoning board, the applicant went to the New Hampshire Housing Board, and the New Hampshire Housing Board overruled the Laconia Zoning Board. So tonight, when we talk about it, the only thing that you can probably be concerned with is if you want to put any provisions on that rental. So with that, I will let you speak.
Thank you very much, and good evening. My name is Kate Mahan. I represent the applicants, William and Andrea Vessels. We are, as you noted, we are here again today following the recent decision of the Housing Appeals Board. As your agenda indicates, the HAB vacated this board's decision to deny the application for special exception. So we are not here today to relitigate the application, but rather to address any reasonable conditions that you feel are appropriate given what this board has already considered on the application. To that end, and speaking with this board's counsel, my understanding is the only remaining concern for the board was the presence of pets on the property during short-term rentals. My clients are very willing to have a restriction as a reasonable condition for approval placed on the property that they will not have pets on the property during short-term rentals. With that, as I understand that to be the only concern at this time, we would request that you approve the application with this sole condition. To the extent that there is additional commentary from the community this evening, I would like the opportunity to address them. Mm-hmm. We are not aware of additional concerns. Mm-hmm. We understand that in suggesting this single reasonable condition on pets, that this is the only thing that the board had in front of it at the time, that it considered this application, and this is what the board was concerned about going into tonight's hearing. Mm-hmm. So to the extent there are new things that arise, we would like the opportunity to at least address those.
Absolutely.
Thank you.
Thank you. And you are correct. At the time, the board did concern was pets, but we have not heard from the community. So 1 minute, please. I will open it to the public at whatever time it is over there. I will open it to the public to comment if there are any provisions you would like to put on the rental. So please come forward if there are any comments you'd like to make.
Can I move this? All right, I understand what Attorney Mahan has said, and I understand where the board's coming from this, but I would like you to hear me out on this.
Your name, please?
It will all come together. It will
Okay.
all come together. I apologize.
Okay.
Okay, my name is Tim Gilligan. I reside at 94 Chapin Terrace, and I'd like to say good evening to everyone. I'd like to start with a comment that I'd like to go into the official municipal record. The state HAB overturned this decision based on unverified, inaccurate statements because the directly impacted neighbors were blocked from participating due to a complete lack of statutory notification. Mr. Moore, you have that. We were not notified by the New Hampshire Housing Board of Appeals of the vessel's appeal and thus had no opportunity to present our case, which probably would have stopped this. This New Hampshire Housing Board of Appeals decision to vacate Laconia ZBA's second denial of a special exception was made based on a narrative given by the vessel's attorney, Kate Mahan. It's easy for the New Hampshire HAB to make a decision based on a one-sided story. Us, the abutters, were denied the fundamental right to a fair hearing, and I don't know how this is called justice. The Laconia ZBA heard this case several times and made the right ruling, but the New Hampshire Housing Appeals Board hears the story from the vessel's attorney, Kate Mahan, who represents her client's best interest, and that's it. No opportunity to rebuke or lay out the facts for an important decision like this. I think it's outrageous. If the city of Laconia doesn't stand up to this with the state, you'll be seeing this, and I'll say this to the city, you'll be seeing this all around the city, in all the neighborhoods. With this, I'd like to give this out, please, if I could. Mr. Moore? Should be 7 copies there. That's for Council Mahan too as well, okay? Okay. Now, this is a similar package that I gave out at the January 20th meeting. Okay, and I'd like to make a couple of corrections that play big into this whole decision as well. If you please take a look at the second page in the bottom left-hand corner, you're going to see 2 short-term rental reviews in the left bottom corner. Okay, one was for a review for a 5-night stay in July 2025, and the next one was a 4-night stay in August of 2025. I believe the attorney for the city of Laconia, I believe her name was Laura Spector Morgan, and if I'm mistaken, please correct me by all means, at the January 20th meeting, said that I was mistaken when I said that the vessels were advertising and renting short-term. And she said, no, they were long-term renters. They were not long-term renters, okay? They were short-term renters, and this is proof of it. We have all license plate numbers, we have vehicles, we have it all, okay? And we're not looking for anything more than justice and the truth, okay? That's one thing that I do not lie, and I don't like people that lie and twist and turn things, okay? So anyways, she expressed her concerns over the vessels renting it out regardless, okay? And the attorney, Laura Spector Morgan, quickly attempted to correct, that was that woman Jane that was sitting off to the left here. We watched the video 6 or 7 times, and she was on the board, and she said, I guess it's up to you, Jane. And she told Jane that, corrected Jane, and this is how I'm gonna put it, okay, saying it was long-term. It was not long-term. They were advertising, and they had rented it as short-term lodging. It's right there in front of you on page 2, and if you look, there's a lot more than that. Okay? Then she tried to smooth it over by saying something about clicking the boxes. You could go on the Airbnb site, but you couldn't click and you wouldn't be able to make the reservation. Well, they obviously were advertising it with that intention. If you can look, there's 5 dates, there's 6 dates, 7 dates on all the various papers. Okay? So this isn't my imagination. And please understand something. I don't make things up. I talk about facts. And these are the facts. These are right there in front of you. And it was in front of that attorney at that last meeting of January, okay? And she put a twist on it. And she tried to smooth it over, like I said, about the boxes. The vessels put the ads up, and why would she try to put up a smoke screen to cloud the facts? I can prove the attorney misled the ZBA members as well as others. You can go to YouTube video, fast forward, go to the January 20th meeting of 2026, fast forward to 54 minutes and 2 seconds, okay, and watch it. She misrepresented the facts and denied that they were, excuse me, and had advertised short-term lodging. And that small misrepresentation had an impact on this case at the New Hampshire Housing Board of Appeals. I bet those violations were not brought forward in the vessel's attorney Kate Mahan's presentation to the New Hampshire Appeals Board. And that had a direct effect on the decision to overrule the Laconia ZBA and vacate their decisions, both of them. Some of our closest neighbors are not here tonight because they felt it was a waste of time, especially after last month's waste of time. And they feel as though the city is not standing up for our citizens and that the decision has already been made, so why even go to the meetings? I mean, we have a zoning board of appeals for a reason. And the state doesn't know better than you people do. You hear it firsthand. They don't know. Another abutter is an older couple across the street from us. They were planning to go, we spoke as late as 1:30 today, and they could not be here. They notified me a couple hours ago, and she's in the emergency room with a health issue. And she's quite upset about this, so I'm sure that didn't probably help any, but I'm not blaming that, okay? Please don't mistake that. The vessels are running a business, and this is some sort of an obstacle we've had to deal with. They own KAV properties, okay? They rent it out unauthorized before and after the first denial, ignoring the rulings of the zoning board. Of you people, they ignored the rulings, okay? They or their attorney presented untruths about their rental ads that were not the truth and were misleading. And I want to change that because actually that was, I believe, Laura Spector that actually did that. Okay? The owner, William, was not truthful when he said to me in the very, very beginning, would you be okay if we rented out once in a while to family, friends, when we're not using it? They've stayed there 10 times in 10 times in 1 year and 1.5 months. Okay? They would have been renting it out through all that if we hadn't pushed back. He made no mention of Airbnb rental to me, none, okay? I also have copies of 4 other multifamily homes that they own. Okay? They are investors. Please understand, that's what they are. They're investors, okay? If this board approves this appeal with conditions, certain conditions should have to be met, including require that the property owners must reside on site for a minimum of 150 days or live here full-time, as required in the zoning ordinance 235-41M. And if you look at 1CI, it reads, short-term lodging is in an owner-occupied property is considered an allowed accessory use only if the owner of the property resides on the property for not less than 150 days a year. They stayed here last night. That's a total of 10 days. It might even be 9, to be honest with you, since they purchased 82 Chapin Terrace. 411 days they've owned that property, and they've stayed here 10 times, okay? If this thing passes, I would like to see quiet hours, 9 p.m. to 8 a.m., no fireworks, no pets. Please understand the pet situation wasn't about a pet or a puppy like the former chairman had said, a puppy up on my porch. It wasn't about a puppy up on my porch. There was 3 different situations, okay? And what those situations were an indication that no matter how you try to vet anybody in the Airbnb situation, there's only so much you can do, okay? And they can't be there to hold their hands. And William told me that they had a leash law over there, okay, that all animals were going to be on leashes. They rented it out 3 times short-term in the beginning, and all 3 times there was dogs on our porch, which believe me, I love animals, and I actually thought it was a relative of theirs, so we were extra nice, and I'm in my underwear sitting beside a slaughter at 9 o'clock at night, and I have 2 corgis up here, and you can look, the corgis are right in the review. The 2 corgis is right here, right this close to me in my underwear at 9 o'clock at night. Okay, so it's just too much. So it's not the pets. The point is, people don't always do what they're supposed to do, unfortunately, okay? Guests do not exceed 6, campfires out by 10. I would also like an immediate revocation clause for any local violations, as well as violations of anything agreed upon in the approved list of conditions, if it's approved. The owner or the property manager shall be available 24 hours a day with a direct name and number. And if he's away from the property, which he should be living in or residing in, if he's away from the property or if it's rented, at any time, he has to be available. If the owner or the property manager ignores it, does not take corrective action in less than an hour, it's a violation. No, next one's no amplified outdoor music at any time, strict enforcement of the rules of the city of Laconia, a method or a plan by the ZBA for handling violations. Who do we file a complaint to if this, in the city when the rules are broken? I respectfully urge the board to make these guidelines firm if you do choose to pass it. Based on the vessels passed here, it's obvious they don't honor rules or laws for that matter. The vessels rules for their short-term lodges renting, according to William Vessels, and I'm not gonna repeat myself there, that's kind of redundant, okay? And they claim they bought this for their forever home, and I think that sounds great and everything, but they told me they were gonna, my wife, they told us that they were gonna use it, they were gonna rent it out only when they weren't using it. They've used it 10 times, and I'm being generous, in 411 days, in 13 and a half months. They purchased it for an investment property. And it's obvious. Most of us purchase our homes in an RS residential single neighborhood to avoid all this stuff. I hope the ZBA, as well as the planning board, will stand by their 2 previous decisions to deny, and that they will do what is right to fight the HAB. The New Hampshire HAB does not know the entire story, and I truly believe that if they got the whole entire story, including the board members that weren't here when I made my presentation the last time around, there was a lot of things that were in that presentation that I feel as though you people should have heard. And I think that would play a... But I want to be clear on this. We, the abutters, we know our rights, and we have the right to appeal this at the local level, the state level at the HAB, and the Supreme Court. We're going to stand up for our rights, and we're prepared to retain counsel if necessary. And I would respectfully like the opportunity if Attorney Mahan gets up and clouds the air with things that I have the right to rebut. I would really appreciate that from the board. Thank you for your time.
Thank you. Is there anyone else who would like to speak?
Thank you. Mike Conant, Ward 6, also the counselor for Ward 6. I've met with these neighbors on Chapin Terrace a number of times, a great number of times. I met with them this morning. They're very frustrated. I think this board should stand by the 2 decisions that you've already made. One was in August of 25, one was in January of this year, 26, denied both times. We have a zoning board of appeals because you guys know what goes on in the city of Laconia. If you're gonna lay down and let the state tell you what you should do with your zoning laws, that's a problem. I think we should fight it as a city. Let's do the right thing. You guys made a decision twice to deny this. And as Mr. Gilligan said, it went to an appeal board at the state level and no one was invited. That's not justice. That's injustice. So I ask you to stand by your decisions that were the correct decisions and to stand up for the city of Laconia, and let's not be pushed around. We have a zoning board for a reason. I hope you guys continue to do the right thing and deny this, and if we have to fight the state or have another hearing, there is an appeal process that could happen from the city. I know if that doesn't happen, I'm sure that the neighbors will file that appeal, and then that just makes the zoning board look like they're really not doing what they should be doing for their citizens. So thank you for hearing me.
Thank you. Someone else, please?
Hello. Hi, I'm Mike Zagarelli. I live at 85 Chapin. I'm right across the street. I've never met them. I don't really know them, but I think it's about accurate that they've stayed there maybe, probably less than 10 times. I guess my issue is I have 2 daughters, and I don't feel comfortable having different people in there every week with my daughters across, having my young daughters across the street. So background checks only go so far, and we don't know who is staying there, you know? So to me, I like having neighbors that I know. The only reason I knew about the last month's meeting was because my neighbors told me. And I sent you guys in a letter because I wasn't able to attend. You know, my kids are busy with sports right now and everything else, so I was barely able to make it here tonight. To have me keep coming back to do this over and over is a time commitment, and I don't have time. I'm on the run constantly. So, you know, what I said in my letter was what you guys got, so I'm not gonna repeat myself, but, you know, that's what that's kind of what I wanted to clear up, so, thank you for your time.
Thank you very much. Anyone else from the public, please? Seeing none, I will close the public portion of the meeting at 6:50 PM and open it up. Oh, wait, you want to address the concerns? I'm sorry.
No, that's quite all right. I just wanted to make sure there was no one else that wanted to speak
Right.
before I stood up. Thank you, and thank you again. I completely understand where the community is coming from. I think that there may be a misunderstanding of what the HAB process is, and the fact that the city was represented by council at that appeal, and that the appeal is a closed record. You cannot introduce anything else. It is based upon what has already happened, and the city's council was there and made argument on the city's behalf and in support of the decision that you had made at that time. Based on that argument, based on the record as it was presented, the HAB determined that your decision was unlawful and unreasonable and vacated it based on that record. And I just want to make that clear for
Thank
the
you.
community here today. I don't want to get into the merits of this application again. We're not here to discuss that, so I will not address each of the concerns that were raised, particularly by Mr. Gilligan as the prior chair, whose name escapes me tonight, so I apologize for that. But as the prior chair noted, there were 2 short-term rentals that occurred before the applicants were aware a permit was required, and that was because they were told prior to purchasing the property that no permit was, nothing else was required, and that they could simply rent the properties. Once they were made aware of that, the application came in August, and we've been progressing from that since then.
Can we address the provisions that Mr. Gilligan has
Absolutely.
brought up, please?
Absolutely. I don't think there would be an issue for quiet hours. The first time that the vessels appeared before you, they indicated that the rental agreement contains restrictions on such as quiet hours, no
Which are what?
fireworks. I believe it was 10 to 8 is what they suggested, or what is in their rental agreement. Do I have that? 10 to 8.
And it hasn't happened.
Oh, wait, please don't, just, the person at the podium, please, only.
I wrote down 9 to 8 is what.
Mr. Gilligan asked for 9 to 8, and you're saying the vessel's agreement says 10 to 8. So,
The agreement says 10 to 8. As we've indicated, we had already agreed that a reasonable condition on no pets during short-term rentals is reasonable. As far as the others, the vessels have already made themselves available. They have given out their personal number to the neighbors. They, of course, upon approval, would be willing to do that again. So they are available to address concerns immediately. The request for a max of 6 is unreasonable for this property.
what is unreasonable?
A max of 6 occupants
Oh,
is unreasonable. This is a 3,700 square foot house. It has 4 bedrooms. It is currently, I believe, when we're looking at marketing for long-term, or what the vessels would be looking for, would be 10, a max of 10 people in the home. And I apologize that I don't believe I wrote down any other.
you already
conditions.
said no fireworks, that was something Mr.
Correct.
Gilligan.
No fireworks
No
and no
fireworks.
parties at all. And as an additional condition of approval, the vessels would be willing to add to their short-term rental marketing, a statement in bold that would say, this is a quiet neighborhood of permanent residents, and all restrictions, rental, set forth in the rental agreement will be strictly enforced. So it would emphasize to anybody looking at this property that this is not a big rental neighborhood, this isn't Hampton Beach, this is a quiet neighborhood, and it will emphasize that to anybody looking to rent. So they would certainly be willing to do that. To the extent that that there is suggestion that a single violation is gonna come in a revocation, or that's just unreasonable. That's incredibly speculative, and that's exactly what the HAB was indicating against in its decision. If the board has any other concerns that it would like addressed or any questions for me, I'm very happy to answer them.
Does anybody have any questions? Go ahead.
This is an LLC, so this is a business. They're running this as a business, which,
The mere fact that it's an LLC that holds it doesn't mean that they're operating it as a business. This is a holding company that they have. Yes, they are renting it, but frankly, that's not part of your ordinance. I don't believe that's part of your ordinance anyways, whether the owner is a private individual or a business, and it
well,
doesn't
they're supposed
relate to.
reside in it.
No, that's incorrect. I don't know if Rob can speak to that. But that's a.
Can I correct?
No, you may not. Please have a seat. Please have a seat.
It's not an LLC, it's in our family
Please,
trust.
please
Okay.
have a seat.
I apologize, this is my client, so
Okay.
to correct the record, I thought it was in their names personally. Someone said it was an LLC, it's actually in their family trust. It is not held in an LLC, is what he is saying. I don't have the deed in front of me. But that doesn't mean that's the owner of the.
Let Mr. Mora respond, please.
Sure, go ahead, Mr. Moore.
According to the property tax card, it is held by a family trust.
Thank you. Thank you. This LLC isn't the owner of the property. It doesn't mean that they don't own a business, but it's not the owner of the property. And again, the purpose of today's hearing is to talk about conditions on the property. And the ordinance as it was at the time that we filed that application. Mr. Mora could perhaps indicate to you why that 3541M residency requirement doesn't apply here. But as your counsel said in January, and I don't want to speak for her, but that doesn't apply here. And we're here today to talk about reasonable conditions.
Anybody else have a question before I close it for board discussion? Okay,
Thank you.
Thank you very much. So we will technically close for board discussion at this time only. And so we are here to put provisions on the rental. You have heard from the public what they would like to see. Anybody want to comment about what you've heard tonight? Eric? Well, before we had talked about pets. I'm putting you on the spot, aren't I?
There's a lot I'd like to say about this, but it's probably best I don't. Can we put a provision that if they're not going to be in town and locally available to address complaints, that they have a representative or someone in town that is available to address complaints?
Mr. Mora, is that reasonable?
I think it would be reasonable to request that the applicant had a 24-hour contact number that was available for the public for any complaints that were filed.
We already have that.
Okay. Anyone else?
Is there any reprimands if a short-term rental brings pets? Like, I know they'll be in trouble, but is there any ever recourse for the owners of the trust to where that's,
So if you make a condition such as that, then it would be enforceable by the zoning ordinance. So we could take action on that.
So how would that be worded, Mr. Mora?
I think it would be reasonable to have no pets shall be allowed at the property for the short-term, during durations of short-term lodging.
And for all of our benefit here, if somebody is in violation, where they are not, they're supposed to be owner occupied, and we heard that they are not abiding by the city's requirement. How do they lose their opportunity for that license?
So they applied for a special exception because they were not owner occupied. So there is no requirement that they are owner occupied, with a special exception from the zoning ordinance at that time when they submitted their application.
Okay,
At that time, with the zoning ordinance, there was two ways to go about short-term lodging on properties such as this. One, you were owner occupied and you had to have the residency requirement of so many days, which is outlined in the zoning ordinance. The other mechanism to go through was for a special exception. They applied for the special exception because they were not owner occupied.
okay, so we don't have to have that, they don't have to have that. But in terms of any complaints, a citizen would contact your office, I take it, to file a complaint about anything that is bothering them with regards to this?
Correct. If there was an issue on the property and they wanted to report a zoning violation for that, it would be, there's an online submittal form, actually, under the planning department, that you can submit an online complaint.
Thank you for clarifying that. Yep.
Just have a question for Rob. So, just so everyone understands, and for my education as well, so the Housing Appeals Board isn't telling us to rehear this. They're telling us it's approved.
Yep,
Correct.
yep.
I see.
They're giving you the opportunity to correct the mistake that was made, when the board erred in making its decision.
But we don't have an opportunity to correct their mistake.
They don't
Okay.
consider it a mistake. The other thing, Mr. Mora, is the public able to read the order? Because it's pretty extensive as to what supposedly the zoning board did wrong, and I don't know if that's a public document or not.
It absolutely is. It is posted online right now, so anybody from the public can look at it. It is on the zoning board's agenda for this evening under the public hearing for this. Everybody is welcome to go look at it. Additionally, it's on their public record as well, so they're more than welcome to come down to the planning department and review all of their files and correspondence regarding that matter.
Thank you. Mrs. Cheney, you had something?
I'm just having a hard time with the fact that the housing appeals can do this and we have no recourse, that the residents have no recourse. I'm gonna go on the record, it's outrageous. It's outrageous that they can do this to the residents of this city and we can't back up our residents.
We were informed by legal counsel that all we could do was put provisions on this application.
It's still
And that's what
outrageous.
our legal counsel has advised us to do.
Correct. This is also one of those issues that we looked at when the zoning ordinance was rewritten for short-term lodging, which is why it's now prohibited in residential single-family.
Right. So, seeing as how all we are really allowed to do at this moment is to put provisions on this property, and the only thing, apparently, that most of the things that Mr. Gilligan mentioned are already part of the directions from the owners, except the no pets being allowed during duration. Is there anything else you think we need to add as a provision?
Didn't he have campfires out by 10?
Oh, they have something on,
Outside music, is that all in there?
I get the impression that it was in there, that it's quiet, et cetera. I do think it was a good idea to maybe make that statement that this is in a residential area and not however it was presented.
If I could make a suggestion to the board,
Yes.
perhaps if they're going to have a campfire, they're required to get a fire permit,
So they'd have to have a permit for that anyway.
which is also a requirement by state law.
Do the permits have if they get a campfire permit, is it to a certain hour at night, or can they run it all?
I do not know the time limitations on a fire, but I believe there is a start and end time on there, along with the volume of what's allowed to be in there. The fire department
It's
would be
5
the.
PM.
We have a fire permit too.
out by 5 p.m.?
No, you have to wait till 5 PM to start it. And then I think it's till 10 or 11.
Can I speak on a point of personal
No, you
privilege?
cannot, I'm sorry, it's
They
been
keep-
closed,
they
I'm
keep
sorry,
talking
it's
back here, though,
closed.
Just so you know.
We're not listening to them, we're listening to us up here. This is a board discussion. Thank you. So, is there any other thoughts on provisions on this property?
I know the question of occupancy came up, and I think we had discussed 6 people, which I think they found unreasonable. I get that it's a big house, but I also think 10 people is unreasonable.
Should we split the difference and go 8?
I would caution the board on setting an occupancy limit as I believe state law has changed, which prohibits the city from regulating occupancy limits on single-family homes.
Well,
That
thank
local
you.
control I hear so much about.
I know. Thank you, Rob, for that piece of information. Okay, it's still back down to no pets and maybe a statement that we're in a residential zone and be considerate. Anybody else want to add anything? Then I need a motion to get this taken care of, please. Go, Eric.
So how do we phrase this? Is there an application number on this or not?
Yes, there is.
or-
It's right here, right here.
I'll make a motion for application ZB 2026-071 for 86 Chapin Terrace,
To add a provision.
that we add provisions to the Housing Appeals Board's approval of the short-term rental. Those conditions are no pets. They must obtain a fire permit for a campfire.
And the statement that they're in a residential zone and.
They will add a statement to their rental listings about it being a residential neighborhood. What else was there?
No more than 8.
No more than 8
No,
occupants?
no,
we can't do that.
We
I
can't
see.
do that. Okay, so those only 2, the pets and the statement, because the state has the occupancy, we can't override that, and they already have to get a permit for a fire anyway, so.
Gotcha. Okay.
So just 2 provisions.
Just
So
those 2
Those
provisions.
2 provisions, thank you.
What about this?
I think that's going to be, I think they have quiet hours on their document. Do I have a second for that motion? Thank you. Discussion? All in favor? Reluctantly? Thank you. I'm sorry.
Madam Chair, you had 4 vote for in favor. I think there's one that did not vote. Do you just want to clarify that?
Yes, I want to clarify, we have 4 votes in favor. Mr. Whitney, Counselor Hoffman, Marcia Hayward, Nicole Arsenault, and 1 abstaining, Mrs. Cheney. Thank you. Next on the agenda is 39 Gale Avenue, a rehearing. Hi, Christine.
Hi,
Hello.
I'm Christine Riche, 39 Gale Avenue. So we're rehearing this?
You can present again.
Okay, so on March 3rd, or March 9th, we were late on our renewal, so we reapplied. And when I was here last time, we were saying if we had just made that deadline. Well, I pulled up the check and I did make the deadline for the March 9th before the change was made. And then I was denied for not owner occupied.
Right.
Which I think I proved I was owner occupied. There's 5 things to prove. And was said the deed didn't matter, I was on the trust. Now I am on the deed, and I reapplied. So the one thing I was then denied for was hardship. So am I here to present to you my hardship to start to short-term?
Actually, this is so complicated. I want to go through the history as I understand it of
Okay,
this
I have the
application.
timeline.
That you were given, in May of '23, you were given a short-term rental permission to rent your place short-term, May of '23. That application was good for 2 years. So it expired in May of '25. You didn't apply for a new application until you just said May 9th of this year?
March 9th.
March 9th of this year. So we have had from May 25th, a big gap before you came in to get the application renewed. And when you presented your application on March 9th, it got denied by Mr. Mora because it was not owner occupied. Then you apparently got that straightened out. But by the time it got straightened out, then the rules had changed. The city changed that you couldn't have short-term rental in a residential zone anymore. So there's a new ordinance that now forced you to come under the new ordinance. And that's when you came before us and you got denied under that new ordinance. So you have asked for a rehearing and we're giving it to you. But you are going to have to, because we're under the new rules, you're going to still have to meet the variance criteria in order to get it.
Oh, okay, so I meet everything but the unnecessary hardship.
You have 5 categories that have to be met.
Mom, can my mother come up here?
Sure.
And the categories are: granting the variance would be contrary to the public interest because the board determined the criterion was not met. What
Well,
was not met?
because, first of all, you own a 3-apartment condo or a 3-apartment home, and the ordinance really is for single residences. So you're not meeting it for that part because you're 3 units and not a single unit. That doesn't meet the ordinance. And the other part to that is that the zoning laws have changed and you can't have short-term rental in a residential zone. You are in a residential zone and they don't allow short-term rentals anymore.
That was changed on March 9th. Is that correct?
I believe so.
That was a hearing.
Yep.
So we were in March 9th and paid before that was signed. We also have not had long-term rentals in 13 years because we use 2 of the 3 for our residents for family.
Yep.
We have done upgrades on the house and not having it rented for 13-plus years as long-term. The heating is now 1 zone. I mean, I couldn't afford to have 3 different zones. This house is like 1900. I had to have the electrical done because I had the screw-in things, and I could afford to renew that and bring it up to code only to have 1 zone for the whole house.
I think on your tax records, though, it's still a multiple family unit. It's still
So-
not considered a single family, whether you've
And
got
it-
1 zone of heating or 1 zone for electrical. It's on the tax records as multiple units.
And to take that off of that would, taking out a kitchen, to go to a single-family home. So there's no way I could explain a hardship to say that for 120 days,
Mr. Mora, any thoughts on changing it from a multifamily home to a single-family home?
They could submit a change of use, which is an administrative review, to change it from a 3-unit to a single family. It would have to meet the requirements of that. They have 3 kitchens, so they would have to remove 2 of the kitchens.
Oh,
So there's,
okay, because we've done this for 13 years without incident, with the support of the neighborhood,
I know.
and we have no choice here.
The
I mean, we are
problem-
owner occupied, not 100 and some days a year, it's 365 days a year we live there.
I understand that, Ann, and I totally agree, and I tell you, I am very empathetic to this problem. The problem lies in the fact that you have to abide by the criteria of the variance and not the special exception. And because you are coming under asking for a variance, it's going to be very hard for you to meet all 5 criteria. It would be a different situation if this had all been solved prior to March 9th.
Well, we paid March 9th before that meeting,
But
and
you got
before it was
denied.
signed.
But you got denied by Mr. Mora.
When we paid on the 9th before the new zoning, the new variance or ruling
Yes.
or whatever.
He denied you because at that time it was not owner occupied.
it was.
Well, let's see what Mr. Mora has to say. He said he
And
denied you for that
My mom
reason.
lives there 6 months out of the year, and everything that I read, her Florida residents came during COVID so she could vote. She lives here 6 months plus out of the year. And my name was on the trust, even though it wasn't on the deed, that it's a trust that holds the house.
I don't know.
So when they dropped off their application, we asked them for proof of documentation. They provided the city with proof of residency in the state of Florida. So because they provided residency showing the state of Florida, they were denied because they were not owner occupied.
Where-
I was
So-
there for 6 months as the owner, and I've owned the house for 27, 30 years.
We're not a company, we're not an LLC. Just,
I have very little leeway when they provide proof of residency of the state of Florida, when it says in the zoning ordinance, you have to be a New Hampshire resident for owner occupancy. There's nothing I can do about that. In their denial letter, they had 20 days to appeal that decision to the Zoning Board of Adjustment. They did not, and then they applied for the variance afterwards.
Of course we did.
wait a minute,
Yes, we did.
This is a variance application for the new ordinance. It's not an appeal of the decision that was made on March 17th, when they were notified of their requirement that they failed to meet the residency requirement that was outlined in the zoning ordinance at the time of their submission.
and we did 20 days? And that deed was changed?
So at the bottom of the letter that you were provided, it says pursuant to RSA 676.5, 677.15, an aggrieved party may appeal this decision to the zoning board of adjustment within 20 days or the Belknap Superior Court within 30 days of the date of the decision.
And it wasn't appealed.
The decision was not appealed. That time lapsed, and then they applied for a variance application
Right.
under the new zoning ordinance.
And they were denied at that time.
And they were denied. They submitted a motion for a rehearing. The board granted that at this last meeting, and that brings them to here.
Yep. So, do you kind of understand the sequence of events that kind of transpired that kind of forced the hand of the city? That he got an, ownership out of Florida, not New Hampshire?
We had no idea I mean, I've owned the house for so long,
I
I've
know.
lived in Laconia all my life.
I know. And then you get a letter saying that, you know, you have the right to appeal within 20 days, and they didn't get an appeal.
March 17th, so March 30th, I was told I requested a variance.
But you had
So I guess I didn't understand that I had to
You had 20 days to appeal his decision.
appeal. So when I went down to the planning thing and they told me, here's the paper to fill out, that I missed it. I mean, why couldn't somebody tell me down there? I guess it's not their responsibility, but they handed me what I thought I needed right after the denial, which
So-
was March 17th.
That was the city council, yeah.
So staff would have given them the variance application because that would have been what was required for them to do short-term lodging.
Right.
Oh, so I didn't ask for the appeal, so I didn't, oh, so lots of help. Okay. And there's nothing we can do right now.
Well, I would find that it would be very difficult for you to meet the 5 criteria for the variance.
Yes, it is.
And you know, it breaks my heart as much as it does you, but I've got these 5 criteria that you've got to meet, and I just don't know how you're going to do it. You're still allowed to rent long-term. It's just the short-term piece that the city won't, you know, the new ordinance is going to prohibit you from doing.
If they rented it out for 29 days or more, then they would have no issues and you would require nothing from the city of Laconia.
Thank you.
Is there anyone in the public that would like to comment?
My name is Mark Townsend. I live at 47 Gale Avenue. I'm a butter to this. It sounded like there was a little technical glitch and you're trying to shut down a very valuable business, put hardship on my neighbors. I think it's ridiculous. I think the people that live there and the business there is a valuable asset to the city. We have had a problem, Airbnb, in the neighborhood. They were removed because somebody on your board bought the house and got them out of there. But that person on your board can't buy up all the property in the neighborhood and control it. Find some way to make this work. This beautiful business has had many happy people internationally and puts a good reputation for the city. Keep the asset, do whatever you can. Thank you.
Thank you.
Good evening. My name is Kathy Fields. I'm at 30 Gale Ave across from Christine and Ann. I spoke the last time they were here. I think I wasn't quite understanding what the issue was, understanding now that it's paperwork and I'm sure the neighborhood could vouch for their residency. They've been residents for a very long time and run a great business. I guess after what I just witnessed here tonight, I understand why these out-of-staters come in, hire their lawyers, and make their case. We're talking about 2 lifetime residents who are trying to do the best they can with the information they've been given, and I think they deserve a break, especially after what we just saw happen in the Chapin Terrace neighborhood. Thank you.
Anyone else?
Hi, I'm Paula Heiser, and I'm at 29 Gale Ave. I'm right across the street from Ann and Christine. Their Airbnb is quiet and it disturbs no one. And they are a real center in our neighborhood. When you go by their house, there's people sitting on the front porch with Ann and with Christine, visiting, whether it's other neighbors or whether maybe it's their guests. They're sort of the center of our community, and they shouldn't be penalized for a paperwork error that they didn't really understand. So that's my opinion on that.
Thank you.
Thank you.
Someone else?
Hi, everyone. I'm Al Simoes. I'm a neighbor. And I just have a quick question. Can I do that? Can I ask you a question? Okay. If this house were a single-family home, in other words, if it didn't have the 3 kitchens and it only had the 1, there'd be no problem. Did I understand that correctly?
I'll leave it up to Mr. Mora.
Correct. This would have been a single-family residence, and when they had dropped off their paperwork, they had a New Hampshire's driver's license, it would have been permitted.
Okay. And so if that were to change, let's say, and I mean, again, I'm not saying somebody should or would, or I'm just asking. So if that were to change, in other words, if that home, they got rid of the 2 of the kitchens, what would be their recourse at that point? Could they reapply, or, I mean,
Mr. Mora?
drum roll.
So because now it's after the zoning ordinance has changed, it is prohibited in residential single-family.
I'm telling you, that's people before rules. Everything you've heard about this family, this home, this whole 9 yards, it's just wrong. I mean, I understand the dilemma, I do. But it's just wrong. Particularly where kitchen, no kitchen, I mean, these are 2 kitchens that probably aren't even used, frankly, I don't know. There's gotta be a way.
If I could add, I've spoken to several other residents in the city, and when the city updated the short-term lodging ordinance, the planning board had originally recommended that it was permitted in every residential district as long as it was owner occupied.
Right.
When it went to city council back in February of this year, city council's only recommended change to that was to remove residential single-family home from that ordinance. You could have a citizen petition, and I think there would probably be enough residents just here that have shown up this evening that could then change the ordinance to allow it back in residential single-family.
Okay. Well, that sounds like a possibility, right?
Based off of discussions I've had, I think that there's quite a few residents in residential single-family that would also be amenable to that. I think that the goal of the zoning ordinance change was to keep our owner occupied so that you wouldn't have people buying a whole bunch of properties.
Yeah, I get you.
Other examples that have been seen. So I think there's a possible change for that, and I think that there's probably several city councilors that would be supportive of that change as well.
Okay, well, thank you.
I think that would be the best way to make the change would be a regulatory change to allow it.
Thank you.
Thank you, Al.
Karen Salome, 27 Orchard Street, just down the street from Ann and Christine, and my husband and I are extremely supportive of all their efforts and how they keep up their property and their maintenance, et cetera. So my question is, with the rules related to accessory dwelling units, how is that impacting with something like this? So if we were to put on an accessory dwelling unit in our backyard, does that mean we would have to rent it for 29 days or longer to be able to do that?
So that's
How does that work?
That's a good question. Sorry. Do you want me to?
No, please take it.
So the city did recently, we changed our ADU ordinance a couple years ago. City council also added a condition on that to strictly prohibit short-term lodging from happening within ADUs. I think that you could probably also reasonably make that change at the same time if there's a citizen petition request to change it in residential single family.
Thank you.
You're welcome.
We're all getting an education tonight, for sure. Is there anyone else in the public who would care to speak on this? Mr. Pressure.
Jim Prusher, 50 Gale Avenue, almost across the street from Ann and Christine. They have been absolutely zero problems there for all the years they have been there. You wouldn't know that there was an Airbnb there if you didn't talk to them. And one time I saw a young man sitting on the steps, and I said, well, no, Christine, there's a young man sitting on your steps, you know what that, yeah, well, let's stay at the Airbnb. Just, pleasant. Bikers come, they are the nicest people. They enjoy the end of the street with the beaches and so forth, but there's absolutely no problem. I understand the predicament. Believe me, I understand. I was in municipal government for too long. I understand the predicament, and I do appreciate the option, and that may be the way to go. So, thank you very much.
Thank you. And one more?
Good evening again. May Stewart, 1424 Old North Main Street. It seems like there was an error made in the documentation because they are year-round, one of the owners is a year-round resident. So the fact that they gave you the Florida documentation is what sent it through as a denial. Is that correct? So even though they're here more than 6 months.
Correct. So when we asked for proof of residency, they provided proof of residency out of the state of Florida, which didn't meet the ordinance. After they were denied, they then made the change to the deed and the trust to change the ownership, to change the requirements.
Okay, it's just that I know that Christine is a year-round resident, so the fact that she is on the trust but wasn't on the deed, that still would have been fine had she been the person who gave you.
At that time, she was not the property owner.
Okay. I will say, though, that I believe this meets the hardship requirement. This is their only source of income, besides perhaps Social Security and pension for Ann, that there is not a steady, regular income from any other source besides the Airbnb. So I would have you consider that as one of the qualifications for a variance for them. Thank you.
Is there anyone else from the public? Hearing none, I will close the public portion of the meeting at 7:35 and open it to board discussion only. So, here we go. Eric.
First of all, I want to point out that of all the things that have been accomplished in City Council over the last few years, there's been nothing that people have appreciated and thanked me for more than banning short-term lodging in single-family residential neighborhoods. So I know Rob seems to think it's possible to overturn that, and I guess I would just urge you not to. Secondly, I think, so the zoning board isn't about holding everybody to the letter of the law, right? If it was, we would just say no to everyone, and we wouldn't need a zoning board, right? It's about, when does the law get bent? And unfortunately, it's really not about how we feel about it. There's rules. And I think, I can't speak for all of us, but I think we would accept this if we had something to stand on. Because this really does come down to paperwork. Unfortunately, it just does. This is about, even though the residency requirement technically maybe was met, but wasn't documented correctly, it wasn't appealed. And then by the time it was appealed, the rules had changed. Or it wasn't appealed, but the variance application was submitted, but the rules had changed. So I guess I'm saying that I sympathize, and I'd like to vote to help them out, but I don't see where in the rules that we do this, except for it just feels like the right thing.
The other thing to keep in mind is that the decision goes with the property, not the owner. So even that Ann and Christine are great landlords when they go to sell that property, if we grant it, they can have short-term rentals because the decision goes with the property, and it's not because of the owner, and you could end up with maybe not some people that are quite as great as Ann and Christine. So, but I agree with Eric, it's extremely unfortunate, and I appreciate the support they have of the community, but we have a variance and we have 5 criteria that have to be met. Anybody else? Tim?
If we did grant the variance, could one of the stipulation it has to maintain outdoor occupation? If it is, you know how it stays with the house, is that something that could be added?
No. Yeah,
Okay.
you have to meet all 5.
Yes.
All 5. And there isn't, I don't even know where you would put that.
Yes.
Do you want to try? Any other discussion?
Yeah, I guess I'm just curious about the number of bathrooms being a factor in the zoning of the house, because I'm sure if you look at all the short-term rentals that have been grandfathered in under our recent ordinance, I'm sure a lot of them have more than one kitchen, right? Or, right? I mean, an owner-occupied short-term rental certainly has 2 kitchens, I would assume.
Very few single-family homes have I seen with more than 1 kitchen. I have seen.
Sure. Okay.
I am not the,
It's a
I'm
weird
not the
line to
kitchen
draw, I
police.
think.
But, so we do have building code, and it does stipulate the number of kitchens, and then that breaks it down into the number of units. And then assessing goes out there and classifies it as such a, whatever particular use it falls into based off of the facilities that are available on site.
Even if it's 1 access, but like a mother-in-law suite, that still counts as 2 units.
So a mother-in-law suite is what we would refer to as an accessory dwelling unit.
Okay.
Which are now permitted by right, but they're prohibited to have short-term lodging.
Gotcha.
Okay. I'm going to make a motion to deny, and I will go through the 5 categories unless somebody else would like to do it. Okay. I'm going to deny application ZB 2026 39 Gale Avenue, asking for variance for short-term rental for the following reasons. 1, the category says the variance is not contrary to the public interest, and I'm saying that the variance, if granting the variance were to happen, it would be contrary to the public interest because it is in conflict with the explicit purpose of the ordinance, which seeks to allow short-term rental in an RS zone. We do not allow that. Secondly, the ordinance for short-term is for single-family residents, and 39 Gale Avenue is a multifamily unit. Number 2, you have to observe the spirit of the ordinance, and because number 1, it is contrary to the ordinance, then we are not meeting the spirit of the ordinance. It is in conflict with the spirit of the ordinance. Number 3, substantial justice is done. There is little loss to the applicant because the applicant can still rent the property for 29 days or more for long term, and therefore, you know, the ordinance would be upheld if she continued, she still has the ability to rent. With regards to the value of surrounding properties, there is no evidence one way or the other whether it would diminish the value. And number 5, the hardship case. The applicant must establish that the property is burdened by the restrictions in a manner that is distinct from the other land in the area, and there is no distinction on that property any different than any neighboring property. So there is no hardship with regards to the property. And hardship always deals with the property, not with the owner. And so for those reasons, I will ask for a vote to deny the application. Do I have a second? Thank you, Nicole. All in favor of denial? Okay, doesn't pass. 2 in favor of denial and 3 abstained. Or it should say how many are a no rather than abstention. 2, 3 are a no. So what do we do? Rob?
You need to make another motion until you have a conclusion.
Okay. Eric? It's up to you.
Does it have to be up to me?
It is because you have a different idea than I do.
But that doesn't mean I know exactly how to,
How are you
How
gonna
to
come up,
phrase
how
this.
are you gonna come up with the 5?
could I request a recess? I'm just kidding.
Rob?
Sorry, I don't have a paper copy. This is really annoying to get through.
Of what?
Anything.
Oh,
Yeah.
you need this. Right here.
If you don't mind me
Yeah.
adding in, the applicant did provide a zoning board application where they have described how they believe that they meet the 5 criteria.
If you want to use that, Eric, do that.
Well, I need to look at it first.
Okay.
This one?
This right here.
Yes.
That.
Yeah, yeah, nice.
You're welcome.
You should table it.
There's no application number on there.
Yeah, it's right here.
If I might also add, the board could also rule that I misinterpreted the zoning ordinance in the decision that was made on December 17th, and then consider them a grandfather non-conforming use.
Okay,
Oh, that would be better.
so. Move to approve, but that's not the full thing, right?
ZB 2026,
It's not on the application
I've got
either.
it. You can write it too.
Is this it right here?
2026,
54?
54.
I move to
54.
approve application ZB 2026-54 for 39 Gale Avenue. Finding of facts as listed in the application, and I'd also like to add that I think the city bears some responsibility in the paperwork being messed up based on interpretations and maybe some unclear direction. So I move to approve this.
Okay. All in favor? I think we can thank Mr. Mora for coming up with that solution. Thank you. Because that was a tough one.
I love being wrong.
Thank you, Rob.
Thank you, Rob, for that solution. Thank you very much, and we will move on to our next one. And the applicant for 8587 Garfield Street.
That one was long overdue.
Yeah, Garfield Street. No, thank Mr. Mora. I didn't have that answer.
That was very kind. You did it.
And we thought it was going to be quick this evening for you. How you holding up?
I'll be fine.
Okay.
I just didn't want to miss the meeting because it goes on for so long.
Yes, it does. Okay. This is on 8587 Garfield Street.
So I assume everybody gets this application?
Yep.
So, I mean, I guess I'm hoping that it's self-explanatory. My name is Ron DeDuca. I'm the owner of the property. Asking for a variance, as it says, section 235-33 of the zoning ordinance permit for max residential unit density. So we took a distressed property, turned it into a beautiful house with an ADU, but because of a current family situation, I really need to turn this into a 2-unit, and apparently we're just shy of the green space, and I don't know if I got that worded correctly, but I believe that's the...
You're not being asked about green space.
Okay, then, so it's the max residential unit
It's-
density.
It's the density.
That's what
Yeah.
I guess I'm a little shy on.
Yep.
It is RG zoning, so there's many 2 units in the area. So I am asking for a 2-unit. I'm not asking to add anything to the property. I'm asking for it to stay exactly as it is, nothing additional compared to, you know, what's already there. Just asking it to become a 2-unit instead of an ADU.
Very good. So this property is 0.23 acres, and you would, in an RG zone, they allow 6 units per acre, which means that this lot would have 1.38 units on the lot. He's asking for 2, so we're very close to the 2, and that's what he's asking for. Okay, I will entertain comments from the public. So if you want to have a seat for a minute. If there is anyone who would like to speak for or against this application for 8587 Garfield to become 2 units instead of a 1.37 unit, would you come forward? Seeing none, we will close the public portion of the meeting at 7:50. Open it to board discussion only at this time. This is an easy one as far as I'm concerned. There is no
I'll say
problem
Paul
with
Memphis.
this. Nicole? No problem. So can we have a motion to grant this application then? Anyone?
I motioned out.
I'll motion it.
Okay, I'll go through it if you want. Okay, motion by Mrs. Cheney, second by Eric, to grant the application ZB 2027-00, do we have a, what is that?
002? No, I'm sorry, 001 Garfield
One, I thought
Street.
that was a one,
it
yeah.
is.
8587 Garfield Street, from granting a variance from Article 6, Section 235-33, criteria number 1. The ordinance requires that it be 1.38 units on this lot. Going to 2.0 is certainly not a big stretch to do that, so I think we're meeting the spirit of the ordinance by allowing him to go to 2 units. And if criteria 1 is met, criteria 2 is met. Number 3, there is no benefit to the community that would outweigh the benefit to the owner, so therefore substantial justice is done. With regards to criteria 4, with property, there is no evidence that it would, by going to 2 units, would diminish the neighboring property. Number 5, there is no relationship between the public and the application for the density provision. It's a reasonable use, and it would increase the owner to have, someone to have actual ownership of a home by going to 2 units. Rather than an ADU, he can actually condominiumize it and have someone have ownership of a home. So therefore, for those reasons, I say we grant this application. All in favor? Oh, it was so quick for you. Good luck.
Yeah, but I bet we had you scared.
Huh?
Thank you very much.
You're welcome. Next comes 5 Hilliard Road, please.
Good evening. My name is Daniel Muller. I'm from Cronin Bisson Zielinski. I am covering this matter for Attorney Dunphy in my office. We're here tonight on behalf of Waterview Properties LLC, who is the owner of 5 Hilliard Road here in Laconia. And the reason that we're here is we're looking for a density variance. The property in question is .42 acres. It has been improved in the past with a office building. That building was not in the best shape when my client acquired the property. They are looking to do a mixed use. There will be an office space. And the reason for our variance here is that we're looking to do 16 condominium units, garden-style apartments. We are in the commercial resort district where it is allowed use. My client did in the past, they went to the planning board for a conceptual, originally for 20. They reduced it down to 16. My client is looking to keep it in that area, in part because they're looking from an economic standpoint in terms of selling, not to, if you go too far down to cover the costs, you have to increase the size of the units, therefore increase the cost, and therefore you may miss out on more of the middle market. So we are here tonight, again, only for the density requirement. There are no other requirements that require a variance from. Right now, the proposal is, again, you're talking a 3 to 4 story building. There'll be some parking under. The office will be on one of the lower floors. There are 16 spaces, including 2 accessible spaces outside for a total of 25 spaces. In terms of access, the access will remain off Hilliard Road. We're not looking to do a curb cut off of Daniel Webster Highway. Obviously, that would require more work. With me from Daylight Engineering Surveying is the surveyor in this case. He has spoken to the New Hampshire Department of Transportation to see if they're going to require a turn lane or anything of that nature to accommodate this use. They are not. There are, as I understand, existing sidewalks on Hilliard Road that interconnect with the ones on Daniel Webster Highway. If the board wants, I can go through all of the variance criteria. Some boards want me to read everything. Other boards take a different position. I will do either one, whatever the board would prefer. I can go through each of the criteria.
I've read it. I don't know if you want him to go through it. Do you want him to go through it? No. No? So,
Okay,
yes.
as I
Read it.
said, everybody has their own practice, so I try to
Thanks for asking.
it often is a late enough night for everybody, so don't look to make it any longer than I need to. So essentially, at the end of the day, because it's a .42 acre lot, there is not enough acreage to do the density here, but obviously, as you can see from the drawing, it's been put together, there is space for not only the parking, but for some green space around it, because obviously it is going to be in the owner's best interest to have an attractive development, because that's the way you're going to sell it. What they're looking to do is do condominium units, so yes, they're going to look to sell those to third parties. So at the end of the day, they're looking for something that is attractive, relatively affordable, and that is why we are before the board tonight. I do know that there was at least one letter of opposition that was submitted. I just do want to touch on a couple things. There were some concerns about drainage, traffic, were a couple of the big ones. Number one, drainage, this application, even if we go beyond tonight and this board approves it, still has to go to the planning board for at least site plan approval. Drainage will be addressed there, but even if there was a concern and the board wanted to know, my understanding from the engineer is the drainage generally goes away from the neighboring property towards the street. So it's not going to cause an issue in terms of any drainage improvements on the neighboring property. But again, the planning board will take care of this at site plan approval level. Likewise, in terms of traffic, yes, we're asking for 16 units. However, 16 units here, while it may seem a lot, number one, I would note under the law, there's some suggestion there that this is not, I think, I forget the word that was used, modest or something of that nature, but the power to grant variances isn't limited to just granting modest relief. There's a 1973 case out of Nashua that basically rejected that position long ago, but in any event, in terms of traffic, if you look at your zoning ordinance and the types of uses that this property could be put to, medical office, transit station, things that can create a lot more traffic than you would have even with 16 units there. So in the scheme of things, we don't think that traffic should be a reason to deny the relief requested here. The majority of the other things, again, drainage, I think there's also something on blasting, are more planning board issues. They don't really have anything to do with the density. If I put again, a medical office there, which is another permitted use, it's still the same drainage issue. In fact, it'll be the same issue no matter what I put on that property. Similar with the blasting, things of that nature, so that they will be addressed if those issues do come up at the planning board level and not here. If the board has any questions, I'd be happy to answer them. Otherwise,
In your opening, you mentioned that you wanted to put in garden-style apartments. Did I not hear you say that?
They are going to be condos. That's just for clarification. I must admit, to me, that's not always I understand your commercial resort, they refer to them separately. To me, from a legal standpoint, a condominium unit, it focuses on the form of ownership. And there's really, from a physical standpoint, no true difference between the two of them.
But yet, in your application, you put in a hardship is the fact that you can't build garden-style units.
As I said, I misspoke.
Okay.
They are condominiums.
Okay.
That's what's, as I said, they're putting in condominiums. And actually in the hardship, just so it's clear, I think the line you're referring to is the commercial resort emphasizes the importance of building garden-style apartments and condominiums. So it referred to both of them. Both are the type of development that you're looking for in this zoning district.
But you said that it was a hardship because you can't build, you couldn't accommodate the garden-style apartments, probably to the number of degree that you would like to in order to reap a financial benefit, is the way I interpreted your explanation for number 5. But anyway, aside from that, let me go to this point. You are on 0.42 acres.
Yep.
The zoning ordinance in this particular zone, the CR zone, is 6 units per acre, which means that you have 2 units by right. 2 units by right. And you are asking for 16.
Yes.
16. And I know that you quoted Harborside versus Parade in your application.
Yep.
But Harborside versus Parade also says is that if it is unduly and in a marked degree in conflict with the ordinance, and if you ask me, 16 units versus 2 is an unmarked and unduly expectation.
Okay, and my counter to that is, if you actually read Harborside, plus there's the Chester Rod and Gun Club case, all of them that deal with the public interest and spirit of the ordinance, which are essentially look at the same thing. It's unduly conflicts with the basic objectives of the relevant zoning ordinance.
Yep.
So what they have done over time is that they have said, here are ways that you can show that it doesn't markedly conflict with the basic objectives. You can see whether it threatens public health, safety, or welfare, or if it alters the essential character of the area. And because what happens, and come up with this sort of argument quite a bit, where people will say, well, 16 is a big number. Number one, as I cited, there's the Carter case back from the 70s, which is still good law, which says you can't just say you can only grant slight variances. That's not the law. A variance can be, I could ask for a variance for 25 if I wanted to.
I know.
And just because of the amount, the question is, and as they put forth in the application, does it threaten the public health, safety, or welfare? If I look at this, and let's take public safety, and that usually is where traffic comes in. If I could put a medical office as a matter of right there, which generates a lot of things, or a transit station, even more traffic, sort of hard to say that I am threatening the public health, safety, or welfare by putting in 16 units as opposed to a transit station, which is, as a matter of public policy, a permitted use in that zoning district. So I understand the argument that, yeah, 16 sounds like a big number compared to 2, no doubt. But if you look at the objectives of, and the nature of the zoning there, and what could be done, then I think the argument becomes it really doesn't unduly conflict, because I could come up with a lot of things that would be as or more burdensome that would be permitted on that same lot as the 16 units.
I hear you, but I disagree. I still think 2 versus a request of 16 is a big stretch from the basic understanding of what the ordinance wants. That's my personal opinion.
Yeah, and now we're starting to, and my only counter to that is there is a case called Malachi Glen versus Town of Chichester.
I've read that.
And that sort of argument goes down that path, because once you go down that path to say, you know, this is what our ordinance says, and you're deviating, or you're deviating, in my opinion, too much, you're starting to say, I'm denying the variance for the very reason it was given, in which case technically no variance could be ever given to anybody.
I understand that.
So,
Yeah. But anyway, I'm just pointing out that the ordinance would only allow you 2 units by density, and we're here for density.
Yeah.
So, anyway, I should open this up to the public. So if there are any questions from the board before I open it to the public? Okay, then I'll have you have a seat for a minute, and
Okay,
I will
thank you.
open it to the public for comment. Please come forward. Yeah.
Sitting for a while. Good evening.
Your name, please?
My name is Francis J. McLaughlin Jr., and I've lived on 6 Memory Lane in Laconia for the last 15 years, and I have a home in Methuen, Massachusetts with my wife. And we came up to Laconia in 2009, and we met a visionary by the name of Skip Kelly. And he developed Wares Beach Village, which is where my home is. First home in there, model home. As I said, Skip was going in, he wasn't taking that piece of property. And by the way, I camped on that property as a kid. And my father's not alive, so it was, you know, just always one of the most beautiful places in New England. It's like Winnipesaukee. So Skip developed Wares Beach Village, 85 single homes with all kinds of restrictions that are noted in your documents. And we moved in 2011, and there was a gentleman that lived next door, and basically he used the property as an office, running his business, and on Bike a Week he would park cars there. And that was about it. A dumpster was put in the yard. It was only recently removed. The grass was seldom cut. We have various kinds of animals that have resided on the property, including a very bad bear that walks through every once in a while. But that's the property. And then all of a sudden, one day in the Laconia newspaper, we read that next to Weirs Beach Village, there's going to be this big, mega building with condominiums. When I hear 3 to 4 stories, I hear 5 stories, maybe even taller to fit the number of units they want to put in there. I'm looking at the size of the lot. I'm looking at the trees in my backyard, which is the green space that would go. I'm looking to the impact to my home. Always you look at your own backyard first. And then the impact with my neighbors. And we have, by far, one of the most beautiful neighborhoods in Laconia. As I said, Skip was a visionary. Skip wanted to see Laconia more beautiful, wanted to see, around the lake, around Paugus Bay, developed into something that it truly should be. And those kinds of projects are a work in progress. Now, being one of 85 residents, I have 84 residents, and I would ask them to stand behind me right now. They would stand up and they would say that what I'm going to tell you, they support. They do not support this type of development on that lot. They do support some type of development. They do support reasonable development by reasonable people. They do support visionary development that should go there. And so with that, and Mr. Moore, I have a question for you. I sent a letter, and I believe the attorney referred to my letter as the only letter that has been received by the city. Is that true?
No, we have 7.
Okay, you have 7 letters. That's good. And opportunity to send in more if we would like to, because basically what happened is over the week we started drafting some letters, and everything kind of melded into 3 or 4 significant letters. I would call the Peter McDonald letter pretty significant. I would call the one that Karen and I drafted pretty significant. What's John's last name, Karen? John Adriassi's letter is pretty significant and right on. And do I have to read the letter before? No, I don't think so.
We have 7 letters, and they will be entered into the record.
They will be,
opposition.
okay. But I really want you to really understand that you have 84 people in our development, and our development is large. I think everybody has a couple of cars, everybody has visitors, everybody has UPS every day, mail and everything.
Can I ask you this?
Yes.
You said that your association would be, you're open to development on that land. What is the vision you think it should be? What is it?
I think it should be something similar to the neighbor, which is Weirs Beach Village. I think a reasonable, reasonable land use, not an eyesore. I was at the Salisbury Beach over the weekend, and I saw, when you think of Salisbury Beach and you think of Atlantic Ave, you think of, the old development down there. But the big unit that burnt down a couple of days ago was a fairly new unit. And so do I want something like that next to me? Absolutely, positively not. Do I want something similar to what I have? Absolutely positive. Okay. Across the street from where we are, there are $1 million units being constructed. They've worked on it for 3 years. They had to come into my home when they began construction to discuss with me the dynamiting, which of course they always assure you that nothing will happen, but my lawn has sunk. But it takes time to do something well. And then it really takes time to bring in neighbors, particularly neighbors that are going to be there, that are going to stay there, that want to see their property appreciate, that want to see Laconia become, the shining light that it should be. People should remember Laconia for Lake Winnipesaukee. Laconia shouldn't be remembered for a bad neighborhood or bad development. Laconia should be, and it's there. It's in the word Laconia. It's like Winnipesaukee. It is beautiful. Our neighborhood is beautiful. You know what we're looking for? We're looking for beauty. We're looking for something that's beautiful, that will fit our neighborhood.
Okay.
And that's what we're asking.
Okay, thank you.
And can I just say something in closing? Okay? I think you guys all deserve for what you do. I'm wearing an L because I taught at Lawrence High School before this, and I know politics are different in every community, but really, for the patience and the professionalism that you've shown and the couple of meetings that I've attended, I just really want you to know that I appreciate it. Thank you.
Thank you. Thank you. Someone else from the public that would like to speak for or against this, please come forward.
Thank you. My name is Jim McLeod. I'm actually the president of Weirs Beach Village Homeowners Association. And there's a bunch of other people here in the room joining us today. I also live in the village at 39 Tranquility Turn, so I'm a butter. Couple of things that come to mind, first of all, regarding the density. I know the variance, I know a little bit about it. The variance has to meet certain criteria and all that stuff, and you have to approve that. Density is just one. I worry about the runoff. Right behind this property is our own runoff. We have 85 homes built on the hill by Skip Kelly, about 15 years old, most of them. And we have 3 different runoff areas. Their runoff area will actually be our runoff area. It abuts right against it. There's a single fence. There's probably not more than, if I had to guess, 15 or 20 feet to our property. There's not more than probably 15 or 20 feet to Frank's property, who's the closest one, with a line of trees. It's very close to have a 3-story, 16-unit building. You asked a little bit about a vision of what we might see there. I might see a beautiful 2-family townhouse overlooking the lake there. There's been a mortgage company there. It's been abandoned for a while. It's changed names with a plastic banner on it, changed the names of the mortgage company. I think it's just a place for someone to have the ability to work out of their home, but they can't work out of their home, so they have to have a place of address that they have to do, and that's what it's been for the 10, 11 years that I've been there. It's got a parking lot. That parking lot did park cars. It probably holds, I don't know, the parking lot. I think the gentleman mentioned 16 spots plus 2 for a total of 25, but he mentioned 16 and 2. I don't know where he got the 25.
He's got underground parking.
Okay. Yeah, digging out. There is a little bit of a hill there, and you can get into that, I guess. You can blast it out. We blasted to get our neighborhood in, and things like that. So I worry about that. I worry about the traffic. There is a lot of traffic already. Don't get me wrong. It's Route 3. It's Daniel Webster Highway. It's Bike Week. It's Cumberland Farms. It's a lot of stuff there, right, going on. Right, there's a little camp and cottages place next to us. There's another hotel motel up the street. There's another one down. There's a condo unit on the other side of us. And then there's a little 0.42 acres there that I don't know what it could be. It could be an office building would be a lot less invasive, in my opinion. It wouldn't have the runoff. It wouldn't have the utilities. It wouldn't have it would have daytime traffic. It wouldn't have any nighttime traffic. It wouldn't have blocking. Not that we have a lot of views. We don't. The people across the street have more of a view than we do. But that type of thing, that big structure going in, something lower to the ground that would fit in, as Frank said, with our neighborhood type thing, would be more conducive to what we want there.
Let me ask you, have you gone to planning board? Because a lot of your concerns are something that really come up at planning.
We have not, but certainly would and will. I don't know if they're far enough along here yet.
Well, they have kind of given them kind of a broad, I would say, can they go to planning and express what they want or not?
So
They did a conceptual review on February 3rd.
So the applicant did go to planning board for conceptual review because they're looking to utilize performance zoning. Conceptual reviews are not open to the public. They're just a theoretical idea of what they are thinking about doing.
Yeah.
That's not open to public comment.
Okay.
Design reviews are, I believe, are open to the public, or an actual formal application are open to the public.
Well, that would be good to know.
Yeah.
Okay.
So I don't know how we get to
More.
planning board, but we would certainly be, if anyone would like our opinions or comments. I also know that in our development there, we have 85 homes, as Frank said.
Yeah.
They're all two-story. They were limited to two-story.
Yeah.
I would assume that would have been a zoning thing and a planning thing and stuff like that. So then something comes along that's actually higher than us and gonna go 3 or 4. It just seems like it just doesn't fit in. That's all.
So the only thing that zoning can deal with tonight is density in terms of the height and the number of stories, et cetera. That all comes in through planning.
So I think the .42, the 2 is perfect density. Sounds like it to me. Because the math works, but that would be my opinion.
Okay.
I would urge you on behalf of the 85 residents at West Beach Village to deny this.
Thank you.
Thank you.
Hi, Joanne Pelton. I'm on the Board of Directors at Weir's Beach Village. I was at that conceptual meeting, and at the time, the Planning Commission expressed concern about the density that the applicant was proposing, a 24-unit condominium. And they at that meeting, they expressed concern that the project was too big for the lot size. We are also concerned about storm and snow runoff, as our detention pond is really adjacent to the proposed construction of the 16 units that the applicant is proposing here. We all oppose this plan based on the density of the project on land that is less than a half an acre. And we really don't see the hardship of the applicant and what it brings to the table. Let me see what else I wanted to say. We believe that the unit is too large for a 30,000 square foot lot. And we also expressed concern about where the snow and water runoff will end up. And it would be our responsibility and very expensive if it ended up in our detention pond, because we would be responsible to clean it up. And I urge the board on behalf of all the residents at our village that this application be denied. Thank you very much for your time, and we very much appreciate what you do as volunteers. So thank you.
Thank you. Anyone else from the public, please come forward.
Alan McCarriston, my wife and I own 71 Tranquility Turn. We have 46 feet of abutting fence between us and the property under question. I just want to enlighten with some simple math. As stated, the property is 0.4 acres, with the idea that I believe, if I could restate something, correct me if I'm wrong, that 1 acre allows 6 units?
Correct.
All right. So we're under a half an acre here. Just to be clear, how many units are on the books for this size property, this size land again? How many units?
It would be 2.52.
2.52.
Would be, yeah.
Okay. So in looking at some previous history of this evening, there was another person up here requesting that a residence with an ADU was 1.37 units, I guess, and it was permissible to go to 2. With that thought process and this piece of land that is 0.42. In thinking of the same thing, what could the board exercise or think, since you've already presented this, to be bumped from 1.37 units to 2 units? This proposed site could have 2 units on it, or 2.5
Yep.
units. Could you think that maybe permissible, it could go to 3 units? Just hypothetically. So with that, I just wanted to put that out there and relate it to something that we've already experienced this evening. The other thing that I want to say is, if it was 2.5 units and you want to go up to 16 units, that's a 700% change. 700% change. That's huge. I disagree with this action. Thank you.
Thank you very much. Is there anyone else?
Good evening again. Mike Conant, Ward 6 City Councilor. This is not in my ward, but it is in my city. And controlling development is what we're tasked with doing here at this board. I sit on the planning board, and when the conceptual came in back in February, it was not well received by members of the planning board, and we suggested that he completely rethink his plans. He has now dropped it down to 16 units, which is 16 units on 0.46 acres is absurd. I really think we just need to send a message to this developer to come back with something reasonable, and I just wanted to say that. Thank you.
Councilman Conant, what do you think is reasonable?
Well, that's, if it comes to planning, I mean, we could discuss it there. I think something reasonable would be perhaps 3 units. There, you know, they would need a variance for that. But I think we should throw it back at the developer to come back with something that's reasonable, that you as a zoning board of adjustments could really digest and talk about. This is something you can't even really discuss. I mean, a 700%, as the gentleman said, increase is certainly not in the best interest of Laconia. So that's how I feel.
Thank you.
Thank you.
Anyone else in the public? Please come forward.
My name's John Nolan. I live at 149 Memory Lane. So I'm just down the hill exactly from where this proposed development is going into. One of the things too, we've talked a little bit about traffic. One of the things that we haven't really discussed is the grading that's there as well. When you look at the traffic that goes in and out of this area, it's a very steep climb going in. The idea of trying to get 16 units on this site is going to be very difficult in terms of getting that amount of people in and out of that site, especially you're not going to have any curb cut to Route 3, which means all the traffic is going to have to go onto Hilliard Street. And it's going to be very, very difficult. What also to me is really disappointing with this level of development is that nobody has really come to the community that's around it and have conversations about it, right? And this as a planning document, one document, I mean, I've been involved with $1 billion worth of construction in a previous life. I'm a certified administrator of public parking and transportation demand management. This would never fly in any other place that I've ever seen. So the idea that they even came to Laconia with the idea of 24 units, I mean, that's ludicrous. So I really would like you all to really take a hard look at this and work with them to something that's reasonable in and around the community. Thank you very much.
Thank you. Anyone else in the public, please, that would like to speak for or against? Good
Good evening. Thank you for your hard work. My name is Marie Bright. I live at 40 Memory Lane in Laconia. I was at that planning meeting listening. You got all the numbers. You don't have to repeat them. I'm against it. We don't need Boston up here. I left it because I liked Laconia the way it was. Be conducive to what's around, we don't need another high-rise. Apartments, everybody has 2, 3 cars. Those cars are not gonna fit on that lot. And we don't need a big ugly building. I wanna be on record, I'm against it. Thank you.
Thank you. Anyone else in the public that would like to speak?
Hi, my name is Alicia Emery, and I live on White Oaks Road. And just as a citizen of Laconia, I think it's absurd to think that we should even consider putting that many units in less than a half an acre. And I don't think it meets a lot of the criteria, but especially there is no hardship. Financial is not hardship, and I think that we really need to look at what we want in the city and where we're going to stop seeing this growth.
Thank you, Ms.
Thank you.
Emery. Anyone else? Would you care to rebut some of the comments?
Good evening, Mario Fogaretto, Daylight Engineering and Surveying. I'm just going to briefly go over the drainage that will be handled at the planning board, but the site does grade away from the abutters towards Endicott Street. I've had a conversation with the DOT. I would treat and manage the stormwater and directly pipe it into the existing underground storm drains. I also spoke with DOT about an entrance. They didn't have any issue with the change in use. I told them there would be 16 units, didn't bat an eye. It would just be a driveway permit for a change of use. From an engineering standpoint, I know that it sounds like we're putting a lot of units into a small lot, and that's in fact what we're asking, 16 units. But the lot handles it quite well. We have 38% green space, far exceeding what's maintained, what's mandatory. There is a network of pedestrian sidewalks in an area that is pedestrian-based, the boardwalk. We're walking distance to that. We're on Route 3, a state-maintained road that's 3 lanes wide that sees more cars than any of these side roads. The area is right for this. In fact, it's surrounded by other condo associations. In fact, the association behind us, our butters, have 0.11 acre lots. There's 85 of them, but they don't. 0.11 acre lots does not meet the 6 lots per acre. They're in fact themselves more dense than what the zone says. So my point is the property can handle this, and in fact it would fit right in with every other development in the area. Public water, public sewer, all the amenities are there. There's really nothing holding back physically a lot of this kind of development. Height is a concern. There are height restrictions. We're not looking to seek any waivers or variances to surpass that. We'll meet the parking. We'll meet everything other than getting the number of units, which, again, each development nearby is just as dense. In fact, I think there was a couple of variances granted, just one at the Circle for 27 units on 1 acre. That was what, last year or so, and there's one going up the other way. This area, and this is this is on Route 3. In fact, if we went in with a 2-family home, in my opinion, that would look out of place there, across the street from Cumberland Farms and a big condo development across the street. It just doesn't fit. What does fit is a 3-story condo building, and it's got all the amenities and utilities necessary to handle it.
Thank you.
Going just to emphasize a couple of points again. In terms of what we're looking to do, there's been a lot of we want something else. I really haven't gotten a very clear idea as to what that is, except as the engineer just indicated, maybe a two-family. But the two-family economically, in terms of doing that, is not going to work. It's also going to look out of place in, as was described, what is going on in the area. This is a commercial resort district. And yes, again, on the height, we heard a lot of things, but there is no variance requested. The height limitation in this zone, this is a matter of public policy. The city has determined you can go up 60 feet. We're not looking to go higher to make this a high-rise as it's been sort of suggested. There is no relief sought for that. We are looking to keep it within what is allowed within that zoning district.
So how many floors is this?
I believe if,
The architecturals aren't finalized.
But-
But we have a max height of 60. I anticipate it would be 3 stories.
Thank you.
I'm sorry, we couldn't get at what the
3 stories.
Anticipated.
Anticipated 3 stories was the answer to my question. No public input, please. Any other comment you want to make in terms of rebuttal before I turn this into a board discussion?
I have no further. Did you have anything you want to add?
Yeah. I just think it's worth finding where the harm would be done to the public in granting this. And I think that's a tough one to find on this.
Okay,
Granted, what's in the neighborhood.
okay. Thank you. Closing the public portion of the meeting at 8:35, please. Board discussion only at this time. Comments, thoughts?
I think it's too much. Haven't seen how that-
Could you just speak into the mic? Just so
I'm
we can-
sorry, I just think it's too much on such a small piece of land.
Rob, I have a question for you. So the 16 units and office space exempt from the units because it's not a dwelling?
Correct, office space would
Okay.
be exempt from the density calculation.
Gotcha. It's there, but not, okay, yeah.
Did someone say this was a, like, performance zoning?
It is.
So that doesn't affect the density requirements?
So with performance zoning, you could seek a conditional use permit from the planning board to deviate from density, height, setback requirements, signage, and parking requirements.
But that's the planning board.
And the planning board governs that.
The planning board governs that, not us. So we're here for the density requirement only. That's all we're being asked to deal with tonight. Nicole, your thoughts?
I don't think it's adhering to the guidelines for density.
You think it's too much?
I think it is too much.
Well, we already know mine. I said it didn't, 2 units by right, 2.54 by right, and 16 really exceeds that definition of the ordinance.
I don't disagree that the required density there doesn't actually match the surrounding neighborhoods, but I think I would agree that 16 is too much.
So should we suggest maybe something or just leave that up to planning? Because, we think that 16 is too much. They could probably go more, but I don't know as if it's up to us to make a recommendation.
I don't think it's our job to suggest a number in this case.
All right. It's just that 16 is too much and that, as far as I'm concerned, Tim?
I believe that is going over quite a bit of what is allowed to have us try to agree to it. So, yes, I think it's too much.
So does somebody then want to make a motion to deny the request for?
I'll make a motion to deny.
Second? Nicole, somebody want to go through the criteria for denial? No?
No.
All right, I
Yes,
will.
you
Okay. ZB 2027-2, 5 Hilliard Road is requesting a variance from Article 6, Section 235-33 on maximum density per acre, and the variance will be denied for the following reasons. Number one, that the request for 16 units is an unduly and a marked degree of conflict with the intent of the ordinance, which the ordinance would allow 2 units by right, and 16 is a great degree of conflict with that ordinance. Number two, it would not be in the spirit of the ordinance because, again, 16 units is a marked degree of difference from what the spirit of the ordinance intends. Substantial justice. The applicant can still build on that piece of property. So, you know, there isn't any problem, as far as I'm concerned. He could build 3, 4, maybe 5 units. And also on the fact that it's a corner lot is a concern, perhaps with overdevelopment. And then the hardship, or I'm sorry, the value diminishing, enhancing or diminishing the property. Again, there is no evidence one way or the other what would happen to the values of the surrounding property. Number 5 is hardship. The applicant states that the hardship in his application says the hardship is due to the lot size, making it difficult to build a garden-style apartment. That is in the application, and I am saying that it's not a hardship because he still can build on that lot. So with those reasons, I am asking for a vote to deny this applicant. All in favor of denial? 5 for 5. Sorry.
Thank you.
One more to go.
Does this ever end?
I know, and I thought it was going to be quick tonight.
Thank you, everybody.
Yeah. Oh, don't be sorry. It is terrific. It's not an issue.
Can you check if you could keep people on topic a little more?
Oh, I know. I'm sorry. I'm trying to be polite and give them an opportunity.
We're just talking about this.
I know. I'm trying to
I'm all for giving people their
do
platform, but
I
there's a
know.
limit.
I know.
We don't have to go into drainage.
All you have to do, I live there, is take a ride up there
I
and see.
did. I saw it.
You saw it.
I
mean,
saw it.
what else? You know what I mean?
Thank you very much, you guys.
I'm sure they're gonna come back again, and we'll keep our eye on it.
Well, go to planning.
No, I know.
And no traffic.
Well, you know, Travis, go to your neighbors and talk to them.
If I could just add in, we do have one other applicant that's still waiting to go this evening.
We paid $395 for that building. So even if you build a couple of houses on there,
Rob's giving you
Yeah.
the.
Yeah, we
Okay,
You got the
we have
hook.
to keep going. We have one left. You're welcome. Good night. Good night. We have a rehearing where there's no public input.
You still have 166 Guilford Ave.
Oh, 166 Guilford Ave. How could I forget you? Oh, my Lord. I am so sorry.
Hi, guys, that's okay. I was worried I was at the wrong place.
No, I know. It's been a long night, hasn't it?
It has been. I just said to the gentleman, I said, I hope that many people don't stand up about my camper.
Oh, I know.
It's just a camper.
I gotta pull that up. 166 Guilford Avenue. I've got it in here somewhere. And this is, please state your name and what you're looking for.
So I'm Steve Spangler, 166 Guilford Ave, owner occupied, 2-family. We're on the corner of Sanborn and Guilford Ave.
Yes.
The camper, the house sits more on Guilford Ave. The yard is on the Sanborn side and somewhat behind the house. There's not a whole lot behind the house because there's an elevation there and a wall, a retaining wall and stuff. So the camper was purchased last year. I never got to use it. The whole year paid for it. And, you know, this year we've been diehard about using it. So there's a little nook on the Sanborn Street side in front of our garden that absolutely fits the camper perfect. I think the camper's 20 feet and that spot is probably 21 feet, 22 feet. So it sits between a pine tree and a big shrub. So you really, when you're on the street, you can only see the front of the camper. Other than that spot, I don't see anywhere else I could reasonably put the camper aside from my driveway, which wouldn't be reasonable, you know. So that's, I'm just looking to keep it there.
Yeah, according to the ordinance, it is supposed to be in either in a carport or a garage of some sort, or in the rear of the property, 10 feet from the boundary line. That's what the ordinance says. And so you're saying, and I have gone up there and taken a look at your property, and I am in total agreement, you have no rear yard to put that camper in.
Right, the rear yard's completely not there. Behind the house is completely full.
So, any questions of the applicant?
No.
Why don't you have a seat for a minute, just in case somebody has something pro or con to say?
Yep.
Okay, come on up.
My name's Dina Hackett. I am their neighbor. I'm at 12 Sanborn Street. And I just wanted to say, hey, that it was sad that they moved in and so fast got a violation on that. I do understand the laws, but also the backyard area is such a small, steep part and that you couldn't get the camper on. And I also think that the pine trees that line the driveway, like if from certain angles, you can't even see the camper. It's pretty dense in there. And also, you know, it's just, it kind of fits. There's like a white garden fence and then it's white and right next to it. I don't find it visually unappealing at all. I kind of like it there. It blocks Guilford Ave and I get a little more privacy. Also to say that, excuse me, I talked to my mom my parents are the property owners at my house. And she's in total agreement on this. I guess she called and spoke to somebody who she said was so helpful, asked all her questions, and just said, you know, we've had stuff in the past with neighbors on the other side, you know, wanting to do things. And this just seems like such a non-issue, honestly. Yeah, so that's really all for me.
Thank you. Anybody else for or against? Let me close the public portion at 8:45, 8:45, and open it to board discussion. Anybody?
I have no issue with this.
No issue.
I don't either. He doesn't have a rear yard. I mean, he can't be in compliance with the ordinance with the way his property is.
Unfortunately, he has two technically front yards as well, so.
Exactly.
Yes.
Yeah, so I need somebody to make a motion, please.
It's your turn, Tim.
I'll make a motion to
Grant the variance.
grant the variance for ZB 2027-003 for all the reasons given here and in their application.
Second?
Second.
Eric, all in favor? There you go.
Thank you, guys.
I am so sorry, it was
I'm
so
so sorry
quick.
you had such a long night. I don't know
We're
how
not
you guys do
done.
it.
We're not done. We
We're not
got
done.
one
One
left.
more thing.
Experience, and you all, I mean,
Thanks again.
You're welcome.
more power to you. Thank you.
Good night. Thank you. One last one, rehearing on application 2026-35, 238 White Oaks Road. And all it is requesting a continuance to September the 21st at 6:30 PM at City Hall. Second?
Do they get like a bulk discount on these, or?
I second that.
Second, all in favor for a continuance on September 21st, 6:30 PM at City Hall. Make sure I say those things so I don't get into trouble with Mr. Mora.
Listen, I am so sorry, Rob. I totally misunderstood what you told me. I thought you told me they were an LLC and therefore couldn't do the short-term rental. So however I misunderstood you, I am so sorry.
I would like to adjourn the meeting, please, at 8:45. All in favor? Adjourned.
Certainly
Oh,
not.
my God.
It's been worse.
Oh, this will be short, sweet tonight.
I know, I thought it was gonna be short and sweet. Rob, thank you so much for solving
Thank you
that
for
property